What I have for you today is a follow-up on the PepsiCo case that we discussed earlier this year, where it now has been appealed. So let's have a look at it. We had the Federal Court of Australia, and the issue here was that PepsiCo was receiving payments from a bottler for use of the PepsiCo brand, and the tax authorities and the judge said that that should have been subject to royalty withholding tax because part of the payment was for royalties. It wasn't only for the syrup. So PepsiCo appealed that case, and we now had the Federal Court of Australia, the full court, which made this decision. And let's have a look and see what it says. I'm going to go pretty high level over it because I am pretty sure there will be another appeal to this case. Just to jog our memories, you had the PepsiCo group in the US that also had the Stockley Van Camp group, which sells Gatorade, and they were making an agreement with Asahi Breweries in Australia, the subsidiary of Asahi Breweries in Australia called Schweppes Australia. And what would happen is that both these companies would sell concentrate to the Schweppes Australia, and Australia would then bottle the concentrate, put in carbonated water, put on the labels, etc., and then distribute the Pepsi for PepsiCo in Australia. It's important to note that Asahi and PepsiCo are two unrelated parties here. And you can see below what the EBAS itself has said, that there will be distribution and that PepsiCo could nominate a group company to sell the syrup instead, which is what they consequently did. You had a Singapore company called CMSPL, which made the syrup, which then sold it to PepsiCo Beverage Singapore, which actually was an Australian incorporated company and I believe also taxpayer in Australia. And then they sold the syrup to PepsiCo. And it was this transaction that was attacked by the Australian tax authorities and for which they said there should have been a royalty withholding tax for the use of the trademarks from Schweppes to the PepsiCo group and to Stockley Van Camp, which held the Gatorade trademark. So to just summarize the facts, during the relevant year, CMSPL produced concentrate according to the recipe formula provided by and with flavor keys supplied by PepsiCo and SVC. The company also supplied the concentrate to PBS, a member of the PepsiCo group that was incorporated in Australia. PBS was nominated as the seller by PepsiCo. We know that already. PBS supplied the concentrate to Sapple, which is Schweppes Australia, which then in the appeal case gets referred to as the bottler, and PepsiCo Australia gets referred to as the seller. And Sapple paid approximately 240 million Australian dollars during the relevant years, and PBS, or the Australian company, transferred almost all of this money to the Singapore syrup maker. So there was not a lot of tax to collect in Australia from the PepsiCo PBS seller. And the commissioner attacked the case on two alternatives. The first was the royalty argument, and we're going to look at this in the appeal. And the second one was a diverted profit tax. Now, the taxpayer won on both grounds in first instance. The commissioner appealed these cases, and I'm only going to look at the royalty cases because I think the diverted profits tax is too national for us to really care about as an international tax, even though at some point we will look at a case like that because there are a number of countries that have something like a diverted profit tax. So the court of first instance had decided, it's been concluded that in relation to the consideration for issue, so you pay the consideration for the use of the trademark, that the payment made by Sapple were to an extent consideration for the use of or the right to use the items set out in paragraph 4A of 12 and the items set out in paragraph A to D of the definition of royalty. So that PepsiCo lost in first instance, right? There was a royalty withholding tax due, and quite a lot of the first case was also spent on how to calculate this royalty. The judge said, I have also concluded that PepsiCo and SVC, as the parties to the EBAS, were entitled to receive the payments by Sapple under the EBAS. So even though Sapple paid to the Australian PepsiCo, it was actually, in the judge's view, PepsiCo and SVC that received these deemed royalties. There's a lot of deeming going on here for a third-party transaction. PepsiCo and SVC nominated PBS as a seller of the concentrate under the EBAS and thereby directed Sapple to pay PBS. In these circumstances, the relevant portions were dealt with on behalf of PepsiCo and SVC, even though in this case it was quite important whether PepsiCo Australia acted as an agent, which both the taxpayer and the commissioner said it's not. There was this concept of receiving money on behalf of, right? And this gets referred to later in the appeal as well. And then the judge in first instance said, accordingly, I consider that the relevant portions of the payments are deemed to have been paid by Sapple to PepsiCo and SVC as royalties, and there should have been a royalty withholding tax due. Now, PepsiCo was not happy with this. I'm happy that PepsiCo appealed the case because, quite frankly, this case will cause havoc in international tax law if it continues. Imagine if Mercedes distributes Mercedes cars in Australia. Does it now have to pay a royalty withholding tax because the distributor is using the Mercedes brand? Or if Pfizer is selling pharmaceuticals in Australia, does the distributor now have to withhold part of that payment as a royalty for using the Pfizer product brands? It seems funny to me. So the majority conclusion in the appeal was the payment made by the bottler to the seller did not include any element for the license to use the trademarks and hence were not royalties. They were also not income derived by PepsiCo or SVC. PepsiCo or SVC are not liable to pay royalty withholding taxes on the payments made by the bottler to the seller. And here we are done already. But we had a dissenting opinion from Judge Colvin, and we will look at it because it uses more or less the same material to come to the opposite conclusion, but it was a minority opinion, so it does not apply for the outcome of the case, right? And Colvin said whether part of the amounts paid by the bottler were as consideration for, like the court in first instance said, the relevant intellectual property. And then in his conclusion, he writes, to label the grant of the right to use the trademarks as being given royalty free, which is what one of the contracts said, could do no more than to say that there was no monetary consideration beyond that which was provided for elsewhere in the EBA, namely in the form of the price per unit of the concentrate. So he said the price per unit of the concentrate included a royalty as well. There remained the question whether any part of that amount was paid as consideration for the use of the trademark. For the reasons that have been given, and we'll look at that at the end, that amount was in part consideration for the use of trademarks and was therefore a royalty to that extent. And then he also answers the question whether the amounts paid constituted income derived by PepsiCo and SVC. And he says no. He says, as has been explained, if a relatable entity was nominated the seller, which happened here, then the obligation to pay the concentrate from PepsiCo became an obligation to buy from the related entity and not from PepsiCo and SVC. Once the nomination was made, all of the amounts to be paid were owed to the related entity. And here he ends up saying, you know what, I do agree with the majority of judges, because even though this might have been a royalty, it was never paid to PepsiCo or SVC. It was paid to a Australian entity, in which case I believe Australian royalty withholding taxes do not apply. It follows from the conclusion as to the derivation of income that PepsiCo demonstrated that the trial judge was in error. Their appeals must be upheld. In other words, they lose on the royalty, but they win on the fact that they did not receive the payment, and therefore he comes to the same material conclusion as the majority. So if we look at the majority reasoning, the first thing they say is the payments made by the bottler to the seller were for concentrate alone and did not include any component which was a royalty. Further, the payments were received by the seller on its own account, and they cannot be said to have been paid to PepsiCo and SVC. The commissioner's attempts to bring PepsiCo to tax under Section 128 therefore fails for these two interrelated reasons. And then if we look at these arguments a little more in details, the payments were for the concentrate alone. The judges look at the contracts and they say to determine whether the payments were in part as consideration for the right to use the trademark, attention is to be confined to the terms of the contractual agreement documents, which in this case include at least the EBAs. And Colvin disagrees with this. And then they go on to say, even if there were separate contracts, they were on terms dictated by the EBA because this was the umbrella agreement. The nature of the payments made by the bottler could not be altered merely because Pepsi SVC exercised the option to nominate another entity to sell the concentrate. So just because they now, Australia sells the concentrate, that doesn't mean it now becomes a royalty magically. The EBAs provided that the concentrate was to be sold to the bottler by PepsiCo or their nominee at the price nominated by the EBAs. The ordinary meaning of the language used by the parties, therefore, suggests that what was to be paid by the bottler to PepsiCo or their nominated seller was a price being paid for the concentrate, and therefore as consideration for the sale of the concentrate. There's nothing about the royalties. The EBAs are commercial contracts. It is not in dispute that the meaning of their terms is to be determined by what a reasonable business person would have understood those terms to mean. Right? And the terms say you're buying concentrate, therefore you're buying concentrate. And then they look at the trademarks and they say, we do not agree with the commissioner's submission that the license to the bottler was otherwise being granted for nothing. The license rights did not exist in isolation. And this is what I said in my comments on the first case already, right? And also what the expert witness for PepsiCo said in the first case. Rather, they were intertwined by the bottler's obligation to distribute the beverages in Australia. Thus, in a complete view of the license, is one where we acknowledge that A, the benefits obtained by the bottler in being permitted to use the goodwill attaching to the trademarks. This is what the commissioner has done as well. But then he forgot the rest. The restrictions, both as the product and marketing imposed on the bottler in its utilization of that goodwill. It could only use the PepsiCo brand exactly the way PepsiCo said. The burdens placed upon the bottler in complying with the testing and inspecting regimes. The PepsiCo was allowed to come to Australia to make sure that everything was happening as agreed, both in the plant and in the markets, and the benefit obtained by PepsiCo SVC in having the bottler sustain and promote their goodwill in Australia. Because the bottler promotes the Pepsi brand in Australia, why would PepsiCo not give away the trademarks for free? Because they're benefiting from it. They are getting their brand promoted in Australia, right? If we then go further, the commissioner said this leaves the commissioner's submission that the sale clauses of the ABAS did not specify that the price was the concentration for the purchase of the consideration for the purchase concentrate. There's nothing in this point. The ordinary reading of provision that says that an item is to be sold for a price is that the price is for the consideration for the purchase. Once that is appreciated, the commission's submission that PepsiCo were giving away the right to use the trademarks for nothing must be rejected. I think this makes a lot of sense. And then they just say for completeness, the commissioner did not submit, and we have not need to consider, that the price charged for the concentrate was disproportionately high. And the majority judges are handing a number of bones to the commissioner. It's almost as though they begrudgingly make this decision, and they would have wanted the commissioner to win, but he didn't put the right arguments, and they give him a number of hints. We'll see more through the case, where they say, you should have said this and you should have said that. Maybe we could have done something different. It follows that on the proper construction, the EBAs fixed the price for future sales of concentrate alone, which did not include a component for the license to use the trademarks and other intellectual property. And then if we look at what the remaining of the arguments were the payments income derived by PepsiCo, because that was part of the commissioner's argument. The commissioner was clear that he did not contend that the seller was the agent for Pepsi or SVC, and he eschewed any suggestion that the monies received by the seller from the bottler were held on trust by it for PepsiCo and SVC. His case was instead that the monies had been paid to PepsiCo because there had been a payment by direction. And then they talk about creditors and loans, right? We do not accept this submission. It is well established that the direction by a creditor to a debtor to pay a third party constitute a payment to the creditor. Now, I don't know why they say that this here, because they seem to argue against themselves. But then they go on and they say, the commissioner submits that this monetary obligation arose from the EBAs. We do not see how this can be correct. The EBAs contemplated either a sale by PepsiCo or their nominee. Where a related entity was nominated as a seller, the EBAs were clear that it was the related entity and not PepsiCo that would be selling the concentrate. And they bring up a certain issue here, right? I mean, if the seller bought the concentrate from Singapore and paid Singapore, and now is selling it to the bottler. If you say that part of the bottler's payment is made to PepsiCo, then how is the seller in Australia going to pay Singapore? Because then that money does not belong to the seller, right? The same money can only pay for one purchase at a time, not to one and a half. And the court goes on to say it's not necessary to determine what the answer to this question would have been if we had concluded that the payments made by the bottler did in fact include a royalty for the use of the trademarks. It is possible that the royalty component of the payments might have been seen as belonging to PepsiCo, but it's not necessary to pursue this further, however, since the commissioner did not advance his case on this basis. And again, it's one of those huge bones thrown to the commissioner. Next time, say this, right? It's a bit of a difficult one to understand, because this is exactly what the commissioner said, right? The commissioner did say that the payment to the bottler included a royalty for the use of the trademarks. But I think what they mean here is that the commissioner should have said that the payment was made to the bottler, but that payment needed to be split into two, one for syrup and one for um, royalty, and that royalty, even though accepted by the bottler, economically was owned by PepsiCo. I'm not quite sure how they want to make this argument, but they are trying to throw a bone here. And if we go on and see what they say next, they then we look at the dissenting opinion on payment for the trademarks, and the judge here, I find the argument confusing because it is somewhat circular. But let's see what they say. Significantly, and this is Colvin speaking, the definition of royalty in the ITAA 1936 does not direct attention to the terms in which the amount is described. Rather, it focuses on whether an amount is paid as consideration for relevant intellectual property. The manner in which an amount is described or computed cannot answer that question. It may have relevance, but it cannot be determinative. So the law says, a consideration received for the use of intellectual property or trademark in any way is subject to this withholding tax. That's what he's hinting at. The commissioner called in aid the principles concerned with construing commercial instruments so as not to cause an uncommercial result. So again, read the contract and read it like a commercial businessman would have done, right? So Colvin used the same arguments as a majority. As has been explained, a key aspect of the reasoning by the trial judge was the fact, known to both parties, that the PepsiCo brands were strong and valuable. Respectfully, it is difficult to see why an answer to the question posed by the terms of Section 128B, so the royalties, as to whether an amount was paid as consideration for the use of relevant intellectual property would be determined solely by reference of the express terms of the agreements. The majority says that you have to, right? And without regard to other evidence. Whether an amount has been paid as consideration for relevant intellectual property is a statutory question. And what he says here is it is the law that determines whether this payment was a royalty or not. It is not the contract, right? And then he says there are authorities that have dealt with a proper approach where the task to be undertaken is the identification of the consideration for an amount paid under an agreement. And then he mentions IBM, and he mentions Archibald Holway and Davis, Dick, and Lend-Lease. And the majority has looked at these cases as well, but determined that they did not help the commissioner's case. Colvin comes to the opposite conclusion. He says, and he uses an example where he says, imagine if I lease land or something from a building from someone, and I sell my stuff in that building, and everyone knows that there's imagine a huge amount of goodwill attached to that building, because if you're in the building, you can use the brand, etc., etc. Then common sense says, and old case law says, that part of the payment that you make for the building is not just the land lease, it is also for the use of this trade name. And that is because you need to look at the picture as a whole. And that's what Colvin does with this case. He looks at the picture as a whole. He said both parties knew that the Pepsi brand was valuable, but then he forgets all the arguments that the majority makes as to how this was not just a one-sided benefit for the bottler, because PepsiCo benefited also, and the bottler not only got benefits, but they also got a lot of obligations, right? So Colvin then goes on to say, if the amount is required to be paid under the EBAS is for the contract alone, then the right to distribute the branded products is being afforded without any part of the monetary consideration being attributable to the license to use the valuable brands of PepsiCo. That is that is a commercially unreasonable view. So it's interesting to see how both the sets of judges say you need to read the contract in a commercially rational view, but when they apply the rule, they come to opposite outcomes. And Colvin concludes and says, it follows, in my view, that the amounts provided for by the EBAS, the prices for the unit of concentrate, were partly amounts in consideration for the use of the trademarks which the bottler was licensed to use. And he then still goes on to say, that the taxpayer wins because the payments were made to the to the seller in Australia, not to PepsiCo and SVC. But this case will definitely be appealed, and we will simply have to wait until we get the final appeal to see how the outcome will be. I do hope that the majority opinion prevails because it makes sense and it doesn't require us to rewrite the international tax rules. I know this sounds dramatic, but I think that's what it will come down to. If every branded product distributed in every country now becomes subject to a partial royalty withholding tax.